video is going to take a look at state courts, a very quick overview of some of the functions of state courts and how we get our justices and our judges, and talking a little bit about the justice system at the state level, which will help augment some of the readings about the state courts, particularly Pennsylvania courts. So let's take a look, first of all, at what courts do. In the United States, we do have kind of a dual system of courts where we have state courts and federal courts, and there are state laws and federal laws. And overwhelmingly, about 90% of all the cases in the United States are heard at the state level, and the remaining 10% at the federal level. So when we look at this, the burden of the criminal justice system and also the civil justice system is placed upon the states, which is why they are so important in relationship to our American judicial system. In looking at this, the state court systems are subject to their own state constitutions and laws, as well as guaranteed laws under the federal constitution as well. Now, what do courts actually do? So we have two types of areas in which they get involved in, generally kind of settling disputes under the law. We have criminal courts and we have civil courts. And the idea behind this is in a civil trial, two independent parties, one is suing another, generally disputing that the other person did something wrong to them. And that's a civil trial where one private party files a suit against another private party. In the criminal law, what we're taking a look at is on behalf of the citizens of a state, either the district attorney or the attorney general or some other law enforcement power is essentially trying a person that has committed some or is alleged to have committed some crime against another person. So that is actually the government prosecuting somebody instead of two private parties as we'd see in a civil trial. A second thing that courts do is there are certain cases in which there really is no conflict among parties, but the law puts in place certain guarantees of rights. So for example, when minors inherit money from maybe their grandparents or parents when they pass away, it's up to the judicial system to make sure that that money is used correctly. And even if there is no conflict between, say, a parent that's overseeing that money for their children, there are legal processes that are put into place in order to be able to ensure the rights of that child. So not everything's about conflict. There are also just processes that need to be followed, in which usually, generally, lower courts take a look at those sort of things. And then finally, as we would see at the national level with the Supreme Court or any other court at the federal level, our court systems at the state level also have the power of judicial review. And that just essentially means that they have the ability to be able to review laws and actions by the state government, by local governments as their proxy, and overturn laws in which violate both either the state constitution and the federal constitution, or actions by, say, for example, an executive agency or the governor to determine whether or not those are constitutional or not. Again, either under the state constitution or the federal constitution. So there's a lot of power given to the courts. And the question becomes, how do we organize the court system? Since the Constitution of 1968 in Pennsylvania, we've had what we call a unified judicial system in which all of the courts are aligned under the state Supreme Court, and the state Supreme Court actually oversees the entire judicial system. There are no such thing really as local courts, with the exception of some in Philadelphia and Pittsburgh. All of them then are in a direct line, a pyramid, as we'll see here in a couple of minutes, that is overseen by the unified judicial system. So there are two types of court systems that we have. One is what's called the court of original jurisdiction, and the second is an appellate court. And in the court of original jurisdiction, this is the court that actually hears the evidence for or against one person or the conflicting parties. And all evidence about guilt or civil trials, whether or not somebody's violated a contract, all the evidence is presented at these courts of original jurisdiction, and then either a jury or the judge decides whether or not a person is guilty or whether or not one side wins versus the other. In Pennsylvania, we have two forms of courts of original jurisdiction. We have the Court of Common Pleas, which is kind of at the county level, and that's where the overwhelming burden of court cases in Pennsylvania are heard. And then second, we have a Commonwealth Court. This is part of the Constitution of 1968. They're used to anything involving the Pennsylvania state government used to be heard in the Dauphin County Court of Common Pleas, which is where Harrisburg's located. We created a specific court, the Commonwealth Court, to involve cases related to state government so that the Dauphin County Court of Common Pleas won't be overwhelmed by that. So this is a specific court that is specifically elected by the people. Second of all, we have our appellate courts. So these are the courts that don't necessarily hear the facts of every single case, but rather you have recourse to, if you believe for some reason your rights or procedures were not followed correctly in the courts of original jurisdiction. So we have appellate courts in Pennsylvania, and then finally the Supreme Court, which is the final court of appeals. So let's take a look at how that pyramid shakes itself out. So we start at the bottom with the minor courts that are generally courts like district magistrates, which arraign people. And I mentioned Philadelphia and Pittsburgh, there are traffic courts, and they have a kind of more complicated system than you'd see at most county levels. But those minor courts don't really hear, big cases as we'd see. They really start out at the Court of Common Pleas, right? So these are the primary trial courts for major criminal and civil cases that we'd see in Pennsylvania. So after that, if, in the Commonwealth Court, which hears those cases related to government, state government. So after that, you are allowed to have one appeal, and the Superior Court is the first level of appellate courts, again, hearing whether or not you receive justice in the lower courts. And then finally, the Supreme Court, which is the highest appellate court in Pennsylvania, is allowed to hear its cases depending on whether or not they feel there's a constitutional issue. So you really don't have a right to have your case heard beyond the Superior Court. The Supreme Court has the ability to be able to pick their cases and may deny you, a hearing on your case if they don't believe that there's a real constitutional issue there. So there are 7 justices on the Supreme Court. They are currently 5 Democrats and 2 Republicans, as we'll talk about that. In Pennsylvania, that's a switch from just about 5 or 6 years ago, in which the Republicans controlled it 4-3. And that is somewhat of an issue in Pennsylvania politics about the partisanship. So how do we get judges? We know at the federal level, the president is the one that nominates judges at all levels of the federal judicial system. And then the United States Senate has the ability to be able to confirm them after going through this advice and consent system, where they hold hearings and then confirm them for a lifetime to the federal bench. We have a very different kind of system at the state level, in which we have 4 primary ways in which we get our judges. The first is a partisan popular election. And this is a system in which people run in a primary election to get the Republican or Democratic nomination. If they win, they then face off in a partisan election in the general election, in which a Republican or Democrat, typically not really third parties, they'll face off against each other, and whoever wins then gets the seat on the bench. Some states believe that the idea of being a judge is not something that is inherently partisan, that, we really should have people on the bench who are well versed in the law as opposed to being on the bench because of the fact that they are Republicans or Democrats. So there are a number of states that have nonpartisan popular elections for their judges, essentially meaning that people run in a primary election without an R or the D behind their name, and are elected in the fall again in a general election without an R or a D behind their name. People are supposed to vote on their qualifications and their history. On the other hand, we have a merit plan, which tends to be the pick, really, of people that are interested in judicial reform and a more nonpartisan aspect of this. The Missouri plan's the most popular of these merit plans, where essentially there's a nonpartisan commission which vets some judges, gives a couple names to the governor. The governor picks who they want, and then after a couple of years, the people are allowed to hold what's called a retention election to determine whether or not that person should be retained in their office. So this process is allegedly nonpartisan, where the judicial body, the body in charge of vetting the candidates, is supposed to just pick people on their qualifications, and then the governor picks the person that they believe is the most qualified. Finally, we have the appointment power, as we would see at the federal level, but there are two different ways that this might function. First of all, the gubernatorial appointment model is very similar to what we would see at the federal level, in which then the governor nominates an individual, and then the state legislature gets involved in confirming those people. There are a couple of states that also have a legislative election in which the legislature is actually the ones that pick and confirm the members of the judiciary, but that's relatively rare. So if we take a look at the systems here, what you'll see is that the Missouri plan, this kind of nonpartisan plan, and nonpartisan elections dominate these systems that we see here. Relatively rare are the partisan elections like we have in Pennsylvania, and the appointment process takes place. So, for example, if you're from New Jersey, that's the system that you have there. In terms of length for state Supreme Courts vary depending on what state you're in. In Pennsylvania, most court appointments are for 10 years for all of those people from the Court of Common Pleas on up, and minor courts, particularly district magistrates, for 7 years. But you will see here that in other states, the terms range in length from 6 years through life in Massachusetts and New Hampshire and Rhode Island, who follow the kind of traditional federal system of appointment. How do we get them in Pennsylvania? We have somewhat a mix here. So I did mention that we have a partisan popular election, and that's the way things start off. So, again, you have a primary election in which R's and D's pick their candidates, and then they get to the general election, and people vote, oftentimes on the basis of the political party, because there's very low voter information about any of these candidates. People don't really understand what they stand for, who they are, in many cases. So once you're elected, you never really have to face an opponent again in an election in the Pennsylvania court system. So you have an initial partisan popular election. Then after 10 years, we hold what's called a retention election. And essentially it would just be Judge Jim Vike. Should Judge Jim Vike be retained for another 10-year term on the Court of Common Pleas? Yes or no? So you're not actually facing another opponent. People were just asked whether or not you deserve to have another term. And the idea behind this is, rather than giving a lifetime appointment, what we would focus in on is whether or not you've done something as a judge over the last 10 years that people think might disqualify you from being a judge. So it may be a very unpopular decision. It may be something you've done in your private life, whatever the case is. These retention elections very rarely turn out to be controversial because, again, most people have no idea what judges do on the bench and their history and associated with that. But every now and again, retention elections will prove, difficult for judges. We had a Supreme Court justice in Pennsylvania removed in the early part of the 2000s because of a pay raise in the state legislature that applied to the courts. People got really upset about that, and they ended up removing a Supreme Court justice, and a second one was almost removed as well. But generally, there isn't much controversy about these retention elections. For the most part, people get retained. So, unless you do something wrong, for the most part, once you get elected to the bench in Pennsylvania, generally you'll serve out as long as you want. Now, one of the questions is we always take a look at the court systems in both the federal and state level and talk about them being the least political branch. And for years, there were rules in place in states in which in which our judicial candidates ran for office in political campaigns. And in general, while there were advertisements or were, people had the ability to be able to campaign, generally all they could really talk about was their qualifications for the job, and states limited how they could campaign so that they couldn't really talk about issues that would come up before the courts. They couldn't, badmouth other candidates. It was more just, I'm qualified to be this because I've been a judge, at a lower level for so long, or I've been a law professor, or whatever it is. Well, the U.S. Supreme Court, in a case called Republican Party of Minnesota versus White in 2002, threw out those state regulations that limited what candidates for judicial elections could say during their campaigns. And basically said that, specifically in this case, it was Minnesota's law, that the First Amendment rights of individuals running for judicial elections were being violated by the restrictions on what you could or could not say in your campaign slogans or your campaign ads or flyers or whatever it might be. So since 2002, we've had kind of an unmitigated ability to be able to turn judicial elections into pretty much the same kind of issue ads that we would see in a normal election. It hasn't, however, for the most part, descended into all-out kind of partisan warfare. Most of the time, what we see is most commercials are fairly focused on what we would call trade ads, just discussing candidates' qualifications for judicial service. We also see other things that are kind of coded, like values ads. So, somebody might talk generally about their personal values and their ideology. They might talk about what they believe the proper role of judges is in a society. This particularly is important for conservatives who say that, you shouldn't legislate from the bench. And that's kind of a code word for how you would rule if you were a judge. And then finally, there are issue ads in which there are specific things that may come before the court that candidates running for the bench will take a firm position on to show you what kind of a candidate they would be. So there is, a bit of controversy about the way judicial elections function, particularly in partisan elections like Pennsylvania. That is a topic of reform in Pennsylvania. There's been a push for moving towards the, merit selection or Missouri plan, but that probably will not be happening in the near future. So that's our overview of state court systems, and we'll match that up with some readings.